Welcome to Ask the Expert with noted radio host Steve Sleeper. Each week, Steve interviews entrepreneurs and professionals and shares their intriguing stories of success and service. Now, here's radio veteran Steve Sleeper.
Our guest today is Joe Sensale with the Chase and Sensale Law Firm, offices on Long Island and throughout the New York metro area. Joe, how are you today?
I'm very good, Steve. Thank you. I hope you're well too.
Yeah, good. No, I'm good as well. A lot of what you work with is workers' comp. So tell me, what is workers' comp?
Okay. Workers' comp in New York State is the statute that was enacted over 100 years ago to protect injured workers, that is, persons that sustained an injury on the job or in the course of employment. In simplest terms, it's a no-fault statute, meaning that the injured worker does not have to prove he or she was at fault for the circumstances producing the injury or the condition. It is the exclusive remedy for persons who have sustained an injury on the job. And the statute provides for recovery of lost wages to a degree and medical treatment and care for the injury or condition sustained once either the injury or the condition is deemed compensable.
Okay, Joe, so I've been injured at work. How can workers' comp benefit me?
Okay. Workers' compensation is the exclusive remedy that an injured worker would have in order to receive compensation, which manifests itself as either a monetary benefit or medical treatment for the injury that's been sustained and the disability that comes out of that. It provides for lost wages to a degree and also for that medical treatment. So the benefit, since it is the exclusive remedy, and what I mean by that is that you, with very limited circumstances, you can't engage in a lawsuit against your employer. So the only remedy you have is to go through this system known as workers' compensation. And workers' compensation, then, if you have a compensable claim and there are no issues or the issues are resolved, it would involve the benefit of receiving monetary awards while you're out of work, commensurate with your disability. Whereas if you did not file a claim, you wouldn't be receiving anything. You may use your own sick and vacation time. So it's always imperative to file a claim for workers' compensation so that you can incur those benefits because they may not be available elsewhere.
How do I know if I'm covered?
Every worker in New York State is covered under the workers' compensation statute. There are types of employment, however, that are not covered under the statute. Even if a worker, say, is considered an independent contractor for tax purposes, where they may not seem to be an employee of a company or an entity that employs them, he or she may still be considered an employee under the statute, pursuant to the nature and the text of the statute and the case law that has come out as a result of it.
Okay, so let's say I'm going to come up with a hypothetical example. Let's say that I work in a warehouse, I operate a forklift, and something falls on my foot. Okay, so I'm injured. What's the procedure I need to go through? What should I do?
Okay, classic example. That's a great example. The most important thing to know is that upon the affliction of such an injury, to give immediate notice of that injury to your employer. Advise them that they were injured in the circumstances they were injured at, or under, rather, in very, very brief and general terms, indicating that they had an injury at work. The next thing I would do is determine who the employer's workers' compensation insurance carrier is, so that you know who is the entity that can provide for any benefits that come out of the injury. In New York, by law, that information must be posted conspicuously in the workplace. So it's good to know where that is. It's a poster that is usually issued and put up on the wall. And on that would be the information about who the workers' compensation insurance carrier is. So it's good to know that. And the next thing to do is to seek immediate medical attention for the injury, no matter how minor. And the reason for that is that you want to have medical evidence contemporaneous with the injury and at least an initial opinion as to what the nature and extent of the injury is. Also to indicate whether or not the injury would create a disabling effect. In other words, whether or not that person should or return to work, or if they could return to work in a limited capacity. The other thing that's important is also a timely filing of a claim with the Workers' Compensation Board, which is the state agency here in New York that adjudicates the workers' compensation claims. It may seem simple, given the hypothetical example that you gave, a box falling on someone's foot. However, it's a little more subtle when a worker sustains what's known as an occupational disease, for instance, carpal tunnel syndrome, something that does not involve an obvious trauma. For that, the time to file a claim starts when the injured worker is aware or was advised by a healthcare provider that the condition that's being claimed resulted from the performance of occupational duties. The classic example there is somebody who works with a keyboard all day and then winds up with symptomatology that may be suggestive of carpal tunnel syndrome. And if that's the case, that individual should seek immediate medical attention once the symptoms onset and get an opinion with respect to whether or not those symptoms are related to the occupational duties. And then at that point also immediately advise the employer that there may be a pending claim for that. There are legal requisites for a viable workers' compensation claim, and those items, medical attention, notice of the injury, those are all integral to that. So that's what I would I would recommend somebody know what to do in the circumstances that you described.
Yeah, that makes a lot of sense. Now, okay, so I return to work. Do I still receive workers' comp?
Well, in most instances, the answer to that is no. However, if an injured worker still maintains a disability and returns to employment where he or she does not earn the same wages as before the accident or before the onset of the disability from what I referred to earlier as an occupational disease, you can make a claim for the reduction in wages so that theoretically you could still receive a benefit for workers' compensation even though you've returned to work. And of course, that return to work and the reason why you make less money is because of the disability that's associated with either the injury or the occupational disease. If an extremity is injured and you are able to return to work, though, in full capacity, and by extremity we mean arm or leg or hand or foot, fingers and toes, there is the potential for an award for the value of that injury that's eventually determined by the opinions of medical professionals, on both sides, meaning the injured worker's healthcare provider and any expert that may be retained by the workers' compensation insurance company. In some instances, you can resolve your claim in the entirety, meaning that you can give up your right to future wage loss benefits and medical treatment in exchange for a monetary amount. That's also possible, and it depends on who the employer is and whether or not the insurance carrier is amenable to that kind of thing. It's not a guarantee that you can settle a case like that, but it is possible.
Okay, so do I need a workers' comp lawyer?
Okay, there is no requirement that an injured worker retain an attorney. However, the workers' compensation system in New York is adversarial in nature. The employer or the insurance carrier for the employer have diverse interests from that of the injured worker. In all but a very small number of cases, the diverse interests will manifest themselves at some point during the life of the case. For instance, when a medical expert retained by the insurance company renders an opinion that the injured worker is no longer disabled, but the injured worker's healthcare provider is of the belief that he or she remains disabled, litigation will result because you have diverse opinions, which can involve whether or not an injured worker receives any ongoing benefit or medical treatment. That involves cross-examination of those experts. And to be effective, you would want somebody skilled in doing that, such as an attorney. Attorneys retained by injured workers only receive counsel fees or attorney's fees when a monetary award is secured by the attorney. And still, any fee that's even requested by an attorney is ultimately determined and approved of by the Workers' Compensation Board through its judges. And because of that, since there's no cost to retaining an attorney from the onset of the case, it's best to retain an attorney from the beginning, since that attorney will be the active participant throughout the life of the case and may be able to see pitfalls on the horizon.
Yeah, that makes sense. Now, Joe, tell me, what's the most common question you get?
What's going to be the result to the injured worker in the future? What kind of future monetary award would I be receiving? What kind of treatment will I need? And I think people ask that question not because they're seeking some sort of windfall of cash or anything like that, but I think it arises out of a concern for providing for oneself and one's family. Remember, this is an injury that occurs on the job that may prevent you from returning to that job. So in a good portion of cases, an injured worker may have a permanent problem that prevents them from returning to work and therefore may not be able to generate the wages necessary for them to meet their monthly or weekly expenses, or if they have a family, to provide for them as well. So that's the most common question. It's often asked almost from the very beginning because people are concerned at the very beginning because this is something that is new to them, not being able to perform their job. It's often difficult to answer, and in certain circumstances, in most circumstances actually, it's difficult to predict that. However, as you can see the case progress from the initial stages, you kind of get an idea of how to answer that question for an individual. And again, it takes into account issues that may develop along the way so that you can advise the injured worker or your client at that point, what to expect. And there's been some very recent changes in the workers' compensation statute here in New York that have drastically altered and to some extent reduced what that future benefit may be. And it does place a concern for an injured worker.
Our guest today has been Joe Sensale. He's a workers' comp attorney, Chase Sensale Law Group, with offices on Long Island and throughout Metro New York City. Joe, how can we reach you?
I can be reached. The best way to reach me or my firm is by telephone, which it can be at area code 631-348-7500. We could do most of our work by telephone. Again, injured workers may have difficulty ambulating or getting around to different places, and we can transmit documents by email, but we can certainly arrange to meet any potential client at any of the offices throughout the New York area if necessary, and sometimes that is necessary.
Hey, Joe, thanks for being on the show today.
Sure, my pleasure.
Thanks for listening to Ask the Expert with Steve Sleeper. Join us next time as entrepreneurs and professionals share their intriguing stories of success and service.